Is it getting cold enough for everybody? How cold is it where you are? Some people have snow. I had rain all day today. It was so cold. Had to put on a big fluffy sweater. And, pretty much trying to maintain. So, my friend, my Telegram friend, should I name him? I don't know. He was showing me that maybe we should read the Federal Rules of Civil Procedure, Rule 67. That sounds really boring. Let's go there, shall we? Okay, so let's see. How do you do this? I don't know. Gonna go to Safari because I like Safari better than Google. Federal Rules of Civil Procedure. Rule 67. That's what it was, right? Let me look. Let me look again just in case. Yeah, Rule 67. Then there's Title 28. We got to read that one next. But for right now, Rule 67. Oh, yeah. This is good. Let's go there, shall we? Every time I kept hearing, who was it? Peggy Hall, the Healthy American, saying, shall we? I always thought about, what was his name? Jim Carrey. Shall we? I always think about, look at that cute doggy. All right, so let's just read what this is all about. Hey, final remedies. I got a book about remedies. I probably should read it. Federal Rules of Civil Procedure. Title 5, 6, 7, 8. Title 8. Let's see. Can I make this any bigger? Can I make it bigger? I'll move my little face out of the way. And let me see. Was that? No. Go back. Yeah. Let me see. Wait. Command plus, right? Yeah. Oh, yeah, that's working. Yeah. Yes. I'm learning. Okay, so Rule 67, deposit into court. Hey, deposit into court. Depositing property if any part of the relief sought is a money judgment or the disposition of a sum of money or some other deliverable thing, a party, on notice to every other party and by leave of court may deposit with the court all or part of the money or thing, whether or not that party claims any of it. Ooh. The depositing party must deliver to the clerk. Oh, that means it's got to be a hard copy, a copy of the order permitting deposit. So, yeah, I guess I sent it my email, but I think you're supposed to, print it out. Then when you go there, you give it to the clerk, a copy of the order permitting the deposit. Okay, so B, investing and withdrawing funds. Money paid into court under this rule must be deposited and withdrawn in accordance with 28 USC subsection 2041 and 2042. Hey, that's the one. And any like statutes for the states. The money must be deposited in an interest-bearing account or invested in a court-approved interest-bearing instrument, like those the Chris court. What is it called? Court. What is it called? Our investment system. Yeah. All right, so let me see. Notes as amended December 29th, 1948, effective October 20th, 1949, April 28th, 1983, effective August 1st, 1983, April 30th, 2007, effective December 1st, 2007. Notes of Advisory Committee on Rules, 1937. Well, let's just see what that says. Shall I scroll down? This rule provides for deposit in court generally, continuing similar special provisions contained in such statutes as USC Title 28, subsection 4126. Now 1335, 1397, and 2361. Did they move it? Original jurisdiction of bills of interpleader. Oh, how do you plead? Original jurisdiction of bills of interpleader and of bills in the nature of interpleader. Okay. See generally Howard versus United States 184 U.S. 676, 1902. United States Supreme Court Admiralty Rules A. Right there, because they are Admiralty law. Admiralty courts, they're on the high seas, you're in the pirate ship, and they're like stealing the booty, them pirates. 1920, Rules 37, bringing funds into court. 41, funds in court registry. Oh, registry, huh? Court registry, That kind of reminds me of bar, British Accreditation Registry, the bar for the lawyers, the good old boys club. And 42, claims against proceeds in registry. Claims against proceeds in registry. Oh. With the first sentence, compare English rules under the Judicature Act. Annual Practice, 1937. 0.22 R11. Notes of Advisory Committee on Rules, 1948 Amendment. The First Amendment substitutes the present statutory reference. Since the Act of June 26, 1934 was amended by the Act of December 21st, 1944, 58 Statute 845 correcting references are made. Notes of Advisory Committee on Rules, 1983 Amendment. Rule 67 has been amended in 3 ways. The first change is the addition of the clause in the first sentence. Some courts have construed the present rule to permit deposits only when the party making it claims no interest in the fund or things deposited. Oh, okay. Example, Blason Stern versus Beech Nut Lifesavers Corp. Oh. 429 F supplication 533 D Puerto Rico 1975. Dinkins versus General Aniline and Film Corp. 214 F sup 281 SDNY 1963. However, there are situations in which a litigant may wish to be relieved of responsibility for a sum or thing, but continue to claim an interest in all or part of it. In these cases, the deposit in court procedures should be available. In addition to the advantages to the party making the deposit, the procedure gives other litigants assurance that any judgment will be collectible. Oh, so any judgment that you have? So a judgment can be collectible? Interesting. Let me read that again. In addition to the advantages to the party, whoever's making that deposit, the procedure, the way of doing stuff, gives other litigants assurance that any judgment will be collectible. Huh. So like if you're suing somebody, they want to make sure that they get their money. Is that what that means? The amendment is intended to accomplish that. Maybe you make a deposit. I don't know. They want you to pay a payment and you deposit it into an interest-bearing account. The second change, okay, number 2. The second change is the addition of a requirement that the order of deposit be served on the clerk of the court, in which the sum or thing is to be deposited. Oh. So you got to go to the clerk of the court and try to put those GSA bonds in there. This is simply to assure that the clerk knows what is being deposited. And I did twice. Here you go. What are these GSA bonds? Oh, no, we're not going to do that here. Give them back to me. No, no, no. This is where you're supposed to deposit them. Here you go back. No, no, no. Then he goes around the outside of his office, closes the door behind me, and comes in there. I'm like, yeah, is this a special meeting? What's the deal? Here you go. You wouldn't take him. He goes, no, I'm getting ready to go on a break. Right. Yeah, sure. Right. Anyways, and what his responsibilities are with respect to the deposit. Are you refusing to deposit? I'm giving you an order to deposit this. I'm gonna have to just be a little bit more firmer, I guess. The latter point is particularly important since the rule, this is the rule, as amended, contemplates, I'm thinking about it, that deposits will be placed, in interest-bearing accounts. Please deposit this into an interest-bearing account. The clerk must know what treatment has been ordered for that particular deposit. Oh. Yes, can you please deposit this into an interest-bearing account? Thank you. This is, what is this? A deposit. It's a deposit. Because you're at a bank. You're at a bank. Those courts are a bank. So you just got to pretend like you're at the bank. The third change is to require that any money be deposited in an interest-bearing account or instrument approved by the court. You know, those negotiable instruments on a piece of paper, and you write all those words on them. It's called money, not the green things. The white pieces of paper. Committee notes on Rules 2007 amendment. The language of Rule 67 has been amended as part of the general restyling of the civil rules to make them more easily understood and to make style, style and terminology consistent throughout the rules. So style, is that like as in capitalized letters? Like the written style or the, was it like style menus, style manual? In terminology, okay, definitions, hey, driver for hire, traffic for commerce, hire, motor vehicle for hire. Terminology consistent throughout the rules. These changes are intended to be stylistic only. Oh, hey, what is this? Receivers and offers of judgment. Let's go back. Let's see what receivers is all about. Rule 66. Is that like Route 66? No, it's not the same. Rule 66, receivers. These rules govern an action in which the appointment of a receiver catch it, is sought, or a receiver sues or is sued. Oh, you're the one that's being sued. You're the receiver of this. But the practice in administering an estate, oh boy, by a receiver or similar court-appointed officer must accord with the historical practice in federal courts or with a local rule. An action in which a receiver has been appointed may be dismissed only by court order. Oh. The appointment of a receiver is sought, or a receiver sues or is sued. I don't really know what that means. You over there, you look like you could be sued. You want to be sued today? I'm going to appoint you as the receiver. Sue juris. I think I'm going to sue you. I'm going to appoint you to be a receiver. Ready for that? Catch it. I don't know what you say. But the practice is administering an estate by a receiver or a similar court-appointed officer. Is that the F-56 appointment? You're going to be receiving this F-56. I'm going to appoint you as the fiduciary over the trust so that you can administer the trust today that we are administering. Officer must accord with the historical practice in federal courts or with the local rule. An action in which a receiver has been appointed may be dismissed only by court order. Whoa. So I'm going to print out the F-56 and fill it out and get ready to appoint the fiduciary. And then they can only be dismissed by a court order, or they can retire like my guy did. You better just retire, get out now, take the $3 million and go. Okay, so now let's see. Notes of Advisory Committee on Rules 1946 Amendment. The title of Rule 66 has been expanded to make clear the subject of the rule: federal equity receivers. Oh. The first sentence added to Rule 66 prevents a dismissal. Oh. By any party after a federal equity receiver has been appointed. Oh, interesting. Oh, except upon leave of court. Hey, that's what happened. That's what happened when I made the CFO a fiduciary. And then he retired. At least that's what I'm thinking. Because I don't really know. Maybe he was extra old And he didn't want to wear a mask. I don't know. But it was just a little kind of suspicious. It happened right around that time. And he didn't take the fiduciary appointment, by the way. And I'm going to get my money somehow. A party should not be permitted to oust the court and its officer without the consent of that court. What does that mean? A party, like, is that like recuse a judge? A party should not be permitted to oust the court and its officer without the consent of that court. Oh, so is that, what does recuse mean, by the way? Anybody know recuse the judge? Like make him to step down? Is that what that means? The second sentence added at the beginning of the rule deals with suits by or against a federal equity receiver. The first clause therefore eliminates the formal ceremony of an ancillary appointment before suit can be brought by a receiver, and is in accord with the more modern state practice with more expeditious, hurry up, and less expensive, cheaper judicial administration. Oh, Moore's federal practice. For the rule necessitating ancillary appointment, oh, like another one. See Starrett versus Second National Bank, 1918, 248, US 73, Kelly versus Queenie, WD, New York. Is that West District, New York? 1941, 41F Sup 1015. See also McCandless versus Furlan, 1934. 293 US 67. This rule has been extensively criticized. First, extraterritorial powers of receivers, 1932. Rose, Harv L 429, Clark and Moore. A new federal civil procedure. Pleadings and parties, 1935. Yale. Gosh, that light is so bright in my eyes. Okay, let me see. The federal receiver cannot be sued without the leave of court, which appointed him. Get out of here, fly. All right, the second clause of the sentence merely incorporates the well-known and general rule that absent statutory authorization, a federal receiver cannot be sued without leave of the court which appointed him. Applied in the federal courts since Barton versus Barber, 1881, 104 US 126. See also 1 Clerk on receivers. Subsection 549 under 28 USC 125. Leave of court is unnecessary when a receiver is sued in respect of any act or transaction of his in carrying on the business connected with the receivership property. But each suit is subject to the general equity jurisdiction of the court in which the receiver was appointed, so far as justice necessitates. Capacity, capacity. Oh, like you know how to do your job, right? You understand fully. Capacity of a state court receiver to sue or be sued in federal court is governed by Rule 17b. The last sentence added to Rule 66 assures the application of the rules in all matters except actual administration of the receivership estate itself, since this implicitly carries with it the applicability of those rules relating to appellate procedure. The express reference thereto contained in Rule 66 has been stricken as superfluous, like, yeah, you're just like extra. eyebrow hair. Get out of here. You superfluous something. Under Rule 81, A1, the rules do not apply to bankruptcy proceedings. Oh, except as they may be made applicable by order of the Supreme Court. Rule 66 is applicable to what is commonly known as a federal chancery or equity receiver or similar type of court officer. Oh, okay. Like when you say, I want to go into the private chambers of the chancellor or magistrate to receive equity. It is not designed to regulate or affect receivers in bankruptcy, which are governed by the Bankruptcy Act and the general orders. Interesting how they're talking about bank stuff and money and bankruptcy, like you don't have any money and stuff. Isn't that weird? You're in a court and you're talking about bankruptcy stuff. Interesting. Like, can you liquidate my assets, please? Like, you know, the Social Security insurance, can I have it all, please? Thank you. And all those tickets and the marriage license and all those things that you were making chattel paper with all my licenses, I would like them liquidated, please. Let's bankrupt the whole account. Thank you. Shall we? Let us do. Since the federal rules are applicable. Oh, federal. Did you notice that? Federal, Washington, D.C. Their rules, because this is part of their federal government, you know, the overlay, the net that they put. It was like invisible, like the Federation, like Star Wars or something. The federal rules are applicable in bankruptcy by virtue of general orders. Oh, general orders. I'm here by special appearance, not general appearance. General orders in bankruptcy, 36 and 37, following section 53 of Title 11 USC. Only, this is like reading directions for playing a game. Gee whiz. Ah, it's so boring. Only to the extent that they are not inconsistent with the Bankruptcy Act or the general orders. Rule 66 is not applicable to bankruptcy receivers. There's so many of these caveats. You could do this, but you can't do that. Can't do this, can't do this, that. You can do this, but you can't do that. Oh boy, only to the extent that they are not inconsistent with the Bankruptcy Act or the general orders. Rule 66 is not applicable to bankruptcy receivers. Okay. See First Collier on bankruptcy if you want more information. Notes on advisory committee rules. Hey, you advisory committee people, got some rules for you. You want to read these notes? They are from 1948. Amendment. Title 28 USC, subsection 754 and 959A, state the capacity. You know, you got to be able to know how to do what you're doing. Got to have the full capacity of a federal receiver to sue or be sued in a federal court. Oh, and a repetitive statement of the statute in Rule 66 is confusing and undesirable. What? What are you talking about? And a repetitive statement of the statute in Rule 66 is confusing and undesirable? What does that mean? Don't be redundant or something, or what? State the capacity of a federal receiver to sue or be sued in a federal court. I don't know. Committee notes. You know that committee that you have over there? You know, that committee that you just formed over there? Got some notes over here on rules. 2007, that's the year that we amended it. So here, read it. The language of Rule 66 has been amended, just so that you know. as part of the general restyling of the civil rules to make them more easily understood and to make style and terminology consistent throughout the rules. So let's change our rules all the time. These changes are intended to be stylistic only, right? Okay, well, I'm done reading that stuff. I'll have to listen to this again because, you know, I didn't comprehend everything. Do you guys comprehend everything? Do you understand? Do you know what was just read? And who's it for? I don't know. We shall see. Let's hear it again and make your comments down there if you know more information. Good night.